And now for the first speaker. Sorry, Michael, for having done this introduction in Danish. I'm sure you have understood most of what I said. Michael McIlwrath is from GE, what we formerly knew as General Electric. Michael is a Global Chief Litigation Counsel. He's based in Florence, Italy, but Global Counsel for GE, which has its headquarters in Houston and London. Michael represents the company in disputes under the rules of international and regional arbitration institutions. And Michael has published widely on mediation. He was chair of the International Mediation Institute in 2009, and he still serves on the board of directors. For 2 years, in 2016 and 17, Michael traveled the world in the Global Pound Conference, a series of conferences to promote and research the future of commercial dispute resolution, including mediation. So in essence, from a company perspective, now a renowned expert in dispute resolution and mediation, supremely knowledgeable also when it comes to the global perception of mediation as a tool for dispute resolution. I'm afraid, Michael, that will have to do. But thank you very much for traveling, taking time off to be here with us. The next 30 minutes is yours. Then I'll be back here and we'll have a talk and I'll open the floor for questions. Thank you very much.
Okay. Thank you very much. That was, I wish you'd been less kind to me to lower the expectations. First of all, thank you for having me here today, and thank you all for organizing such a wonderful event. I am going to make a short comment at the expense of my colleague, one of the other speakers, Jane Gunn, who broke a shoe last night and had to very quickly have it repaired this morning in order to be able to be here. I think both to stand here on the stage and to make a quick exit if she needs to have functioning shoes. And but since we're talking about dispute resolution, I apologize for using, I think, a line that many of you may have heard before, but I think it certainly applies to the topic we're discussing today, which is that, a man goes to a cobbler shop, could be here in Denmark, actually. A woman goes to a cobbler shop in Denmark and sees a sign on the door that says, shoes, high quality, cheap, fast. Pick any two. And that's actually one of the things that we wrestle with, obviously, with dispute resolution is, we, as a company counsel, we're looking at efficiency. We want to have high quality, and we don't want to spend a lot of money. It's very difficult to get that through any sort of adjudicative process. And I think that really is, through the shoes metaphor, the example is a way to encapsulate, Jane, at your expense, kind of one of the objectives that we try to achieve. So I thought that today, given the topic of this conference and what we're trying to achieve, I'd like to speak to you about three sort of general topic areas. The first is to walk you through an actual case that we had. And I think it's a sort of universal and somewhat human case, and one that has remained very much with me because it's not a typical business case. It was a case of an injured employee, which I think has somewhat more of a universal application, something that many of us can relate to. Also, because it was, for us, what we thought was an impossible case. It was a case that could never be settled, and yet we did, through mediation. Then I would like to walk you through the Global Pound Conference data, some of what we learned over the 2016-2017 period with a conference held in 28 cities around the world, asking the same 20 questions to many different stakeholders in commercial conflict. And then finally, I'd like to just wind up very quickly with some thoughts that I think are relevant to anybody who practices in dispute resolution, and that's kind of what are the trends, where does this take us, where do we think, from my perspective as a company counsel and having been participating in this global conference, where do I think the future will be taking us in the next, I'd say somewhat amusingly, but not amusingly, but over the next 5 years, 10 years, 20, 25 years, of what kind of trends could we make some estimated guesses as to where dispute resolution will go. So to start out, this is a letter that my CEO received addressed to him. Garcia was a man named Claudio Santiago in 2007, and we had just bought a company called Vetco Gray that was headquartered in Aberdeen, Scotland. During the course of the acquisition of Vetco Gray, which was itself a global company with thousands of employees around the world, I was aware that there was a claim against the company for an employee who had, a few years before, lost an arm and a leg in an industrial accident. I knew this because I was responsible for doing the due diligence process with respect to the conflicts that this company had. And I didn't pay much attention to it because I did my job of verifying that there was insurance coverage, this was covered, and therefore, being a lawyer, I kind of said, that's not my job anymore, I'll leave it alone. 6 months after we buy the company, we get this letter from the employee. He's not a former employee, he's an employee, but he's not working, he's suing the company, he's at home on leave. He's been suing the company, as he says here in his letter, for a number of years. You know, he had this accident in 2003, we're now in 2007. 5 years of his life have been dedicated to pursuing this dispute. And he sends very graphic pictures to the CEO. Now, I'm a litigation lawyer. I see things that are not nice. I'm sure like many of you do as well. My first reaction was, well, he's just trying to increase his settlement number here. He's gaming the system. He's trying to get some sympathies. But our CEO didn't react that way. Fortunately, a bit more humane. He took the letter and sent it to our head of human resources and to me and said, what can you do to help this guy? So I no longer have a choice. The CEO has said to me, you know, see what you can do. So I do what you do with these cases. I start to find out what is the case about. I called the lawyer who was representing the company, our company, introduced myself, and I asked him, you know, about the case. And he told me, he says, oh, look, I'm very sympathetic towards him. The problem is he's asking for far too much money. We've already paid him quite a substantial amount of money in terms of working towards an initial resolution. He's seeking a greater settlement. He said, the problem that we're facing is that we're in Scotland, in Scottish courts, he wants a jury trial. The judge is going to decide in the next 6 months if we will have this case tried by jury or by the judge. If it's tried by a jury, he thinks that he will have a lot of sympathy and he will have higher damages. We think that we will win this, it will go to a judge, and then we'll be able to work out a settlement. I said, well, thank you for that. I said, have you thought about mediation? He said, oh, I love mediation, it's wonderful. He says, but not right now. We really think that we have to get through this key hearing, and then after that, it would be a good time to possibly mediate. And I said, well, I said, thank you. I said, do you mind if I call the opposing counsel? He said, no, absolutely. So I called the opposing counsel. I had the same conversation with him, which was, and it was interesting. It was the same conversation, but in reverse. He said, well, he says, we do want to settle. He said, I do like mediation. I think it's great. He says, actually, I'm a trained mediator. I'm very much in favor of the process, but we have this hearing that's coming up in the next 6 months. We think that we're going to be able to have our case heard in front of a jury. That'll give us a right to obtain greater damages. We'd like to mediate then. I said, well, thank you. I appreciate that. I said, do you mind if I call Gavin, the Gavin Slesser, the gentleman who'd lost the arm and a leg, his client? I said, of course you can call him. He's your employee. I'm not going to stop you from calling him. So I called Gavin, and who's a worker, not a very sophisticated guy, solid guy. And Gavin, and I explained to him, and Gavin says, and he walks me through what his lawyers told him. He says, but I'm just frustrated that this is taking so long. And he says, always something else. There's always something in 4 months, 5 months, 6 months. I've been doing this for 5 years. There's always some reason. I said, I want to get this over with. I said, well, have you thought about mediation? He said, no, what's mediation? So I explained it to him. He goes, oh, that's great. He said, I want to do that. And so I said, listen, you tell your lawyer, I'll tell my lawyer, and we'll get to mediation. So we both did. Now, it was not that easy because both lawyers, I think, really were positioned, and we also had the fact that we had insurance companies who had to be brought on board. But the long story short, it took us about a month of both of us insisting. We finally got to mediation. We get to mediation. It takes place in Edinburgh, very small room, and there were about 25 people in a room for 14. This is everyone. One of the key points about mediation, make sure your rooms are big enough. And Gavin another thing is so I promised Gavin that if we went to mediation, I said, I can't promise you an outcome. I said, but I can promise you that we will get a very good mediator. to help this. And so we reached out to Cedar, a leading institution in the UK, and asked them to get the best person they could for this type of dispute. And they gave us a mediator named Tony Allen, who specializes in injury type, with people, personal injury disputes, mediating those. So we're at the mediation, and Gavin started, and he actually had a hook for an arm, where he had these like almost like out of a pirate movie, which, by the way, he told me later was for effect. He actually has better prosthetics that he used, but he actually thought, is this way, look, this is his opportunity. And he came in, so he had this almost a pirate hook, where he's holding this shaking piece of paper in his hand, and he reads for about 20 minutes how this had upended his life, how we had, how the suffering that he had been through, and the fact that he had to defend accusations of his own negligence. He said, how can I have been negligent in this? And I tried to explain to Gavin, I said, look, we're lawyers, we have to raise these defenses before we know what's going to happen. But it was very emotional. Even today, thinking about it, I begin to get emotional. And we all had to break then, and then reconvene shortly after that. And there was also some translation issues. I'm American, the mediator was English. These people were from northern Scotland, so we did have some communication problems that we overcame. And the mediation proceeded, and it was a typical mediation with I think, traditional mediation in a more English format, with the mediator going back and forth between the different rooms. And around 3 o'clock in the afternoon, the mediator came into our room, and he said, well, Mike, he says, Gavin would like to have a private meeting with you alone. I said, with me? He said, yes, he'd like to know if you can take a break and maybe get together. And at this point, we had the insurance companies had made a substantial offer. It wasn't a perfect offer, but I thought it was a decent offer that they'd made. And I think he was considering whether to take this offer. We're late in the day of the mediation. So I asked the lawyers, and again, it's not only our money that we're playing with here, we asked the insurance companies, do you mind if I meet with them? They said, no, if you can get us to a deal, that'd be great. So we take a break, and we go to a Starbucks down the street. Gavin brings his girlfriend. It's the three of us. He brings coffees over the table. I'm sitting down. Remember, he brings the coffees. He sits down. He leans over. He looks into me, and he says, should I take the deal? And I said, Gavin, I'm the lawyer for the other side. He says, I know, but should I take the deal? And I said, Gavin, I really, honestly, I can't advise you on that. I said, but I can tell you one thing. And I said, I can tell you what I would do if I were in your shoes. He said, yeah, tell me that. I said, I would make sure, I said, you only have one arm and a leg to get compensated for. I would make sure that whatever deal you get, whether it's the deal today or it's the deal in court, that you talk with your family, you talk with Erin, your girlfriend, and your lawyers, and you make sure it's the best possible deal that you can get. Because you only got one shot. And maybe, I said, maybe this might really be a better option for you. There's no guarantee of the outcome, but you guys have to weigh that. Do you really think this is the best deal that you can get? That's the question I'd be asking myself. Yes, that's great advice. So we go back into the mediation, and the mediator comes and says, so Gavin's rejected the offers. We're going to postpone. And we left the mediation without a settlement. Now, here's why I think this is a story that really is worth sharing. The mediation did not end that day. The mediator continued to be engaged, and for weeks afterwards, we were not that far, and we were not impossibly apart. And I remember the day that I got a phone call from the mediator saying, look, I have a proposal to make. I think we're there almost financially, but I have a difficult question to ask you. And I said, well, what? He says, if we settle, if Gavin accepts the last offer that we have from the insurers, can he have his job back? I said, my God, everybody loves him. Of course he can have his job back. So we settled this case, and I'm very proud to show you that this is Gavin today. He's back at work. He's very happy. He's got a very good career with us. This was an impossible case. This was a case that everybody said could never have been, no solution could have been reached. Gavin's a good friend. That's why I now have these stories. I now know a lot about it from his side as well of the dispute. And what Gavin told me, the last time I was in Aberdeen, we went and had lunch together, and he said he's the biggest promoter of mediation out there. He does. He has friends in disputes. He says, I call them and I tell them that they should try mediation. He says, don't listen to the lawyers. You go for mediation. But what Gavin says is that he could never have settled this case without the chance to say his piece. He said he just had to get that off. And he actually sent me that piece of paper that he read. It's now mine. And I think it's a great example of, we face these challenges as lawyers. We think that these are impossible. You can never get there. The dynamics are such that there are just too many impediments. And yet, lo and behold, we get to the mediation, and somehow we find a way to resolve things. And so I think it's a good illustration, because certainly I've had many other very complex and very difficult cases, but nothing that I was told repeatedly was something by everybody involved could not settle, and yet at the end of the day, we did. So with that as a bit of a long-winded introduction, I'd like to walk you through some of the data that we gathered during the Global Pound Conference about, not just about mediation, but about dispute resolution processes generally. It was really an honor to be chosen to chair this conference, which took place, as I said, 28 cities. We had responses from from 2,000 stakeholders. And when I say stakeholders, I mean lawyers, corporate counsel like me, external law firm lawyers, judges, mediators, arbitrators, representatives of institutions, and ministries of justice. And technically it's 28 cities. Unofficially, it was 29 because Russia went rogue and they did their own. We have their data, but they didn't want to pay us, so they had their own technology. But we did do 29 cities. One consistent finding from all of this data, same 20 questions asked to all of these stakeholders, and we divided the responses according to who it was, which category was being represented. One of the consistent findings was, not surprisingly, is that as we go forwards into the future, we need to find more ways of resolving disputes. That when we had the closing conference in London in July of 2017, Lord Justice Briggs, the UK Justice, gave our keynote speech, and I remember very vividly, he said, the time is over when all cases must travel through the same process to the same courtroom. The idea that we are now at a point where we need to find ways to adapt the processes to better fit the parties and the disputes. And we have the ability to do that with a lot of what's available, what we know about technology. These are the cities where we held it, the conference. So among the global findings, by the way, we got a lot of data from this conference, and we have a preliminary report which is available on the internet, the Global Pound. It's gpc.org, or I think I have a link to here that I can provide you towards the end. But we have the final version of this that will be coming out through the benefit of a grant we received from the American Arbitration Association. So we have a statistical analysis firm that will be publishing our results later this year. But some of the major themes or findings that we found were things that are important are efficiency, a more collaborative approach to dispute resolution, the notion that parties or people generally think that parties should have more informed choices right at the beginning of the dispute resolution process, and that there should be greater familiarity of the in-house lawyers and the external lawyers about the different options that should be available for resolving conflict. So efficiency was one of the big things. Our focus was on access to justice, but focusing on commercial dispute resolution. The main reason we focused on commercial is we could get funding to do it, but really the concepts here are about access to justice. So you can see that we had about 65% of the people really felt that ought to be the key priority for resolving commercial conflict, and which it drives the decision as to which process they're likely to choose. Efficiency seems to be among the top priorities that parties and all the stakeholders give. Interesting point was that on collaboration, we found a big split a bit. We found that that the advisors, the lawyers, really saw their role as being the most important in terms of advocating processes, whereas around the world, outside of the U.S. and other places, or in general, we saw that parties and judges and mediators and arbitrators felt that the parties themselves ought to start being more in the driver's seat. So there was a perception that perhaps external lawyers are driving more of the process than they really should, that more ought to be coming from the parties themselves. consistent with this as well, there's this notion of informed choice, the idea that once we get into a conflict, to go back to the concept of Lord Justice Briggs, that we don't fall just necessarily as a matter of habit down into the same process, that we have a way of adapting to make sure that we fit the process to the parties and to their dispute. And this really comes out to finding ways to mix, I would say, adjudicative with non-adjudicative. And by this we mean very broad categories. It doesn't necessarily mean court litigation or arbitration and mediation, or there are other forms of mediation called conciliation. Again, this is a global conference. We found there are many different types of processes that fall under these two categories. But just generally, there ought to be a lot of adaptability, more fluidity, and choice, and discussion with the parties about which way to go. And finally, and I think now, look, in retrospect, not surprisingly, but at the time this was a finding that I think was worth sharing, was that the in-house counsel role, the people, or if not the in-house counsel, if you're not a company that's big enough to have in-house counsel, the company itself, I think globally around the world it was recognized that the ones who are most likely to influence change, to shape the future of dispute resolution and also shape the decisions in a particular case are really the in-house lawyers. There was a perception, again, and by the way, shared by external lawyers. External lawyers themselves felt that they were the biggest impediment to change in the process. So this was a sort of global consensus that the in-house lawyers need to drive change, and the external lawyers are the ones who are going to be resistant, which I don't think is unfair to external counsel. I mean, external lawyers are there to represent the interests of their clients and go with the things that are most familiar with them, not necessarily something that might be innovative and new. Why test something on a client? And I think there's a natural inclination of lawyers to go in that direction. But it does lead to, I think, something that we need to face into. And then just repeats the point about in-house counsel being recognized as the ones who will need to facilitate change. You see the data here. Again, I can share these charts. We broke it down, as you can see. It's a little bit too small to read here. But we broke it down according to the different stakeholder categories about who perceived what aspect with respect to the different points that were discussed at the conference. We did see some interesting regional differences around the world. Interestingly enough, in Asia, there was a demand for more regulation. They'd like to see more regulation for mediators, for arbitrators, for the dispute resolution process generally. This was not felt in Europe. We found that continental Europe was, interestingly, in being somewhat different from the rest of the world. One is that the different beat that we felt in continental Europe in particular really emphasized strongly, I think, the role of the in-house lawyer versus the outside lawyer above all. And we did not see as marked tension as those two roles around the rest of the world. So we did have a sense that across continental Europe anyway, there was some significant differences. Anyway, these are some of the thoughts, and again, I try to give you very quick highlights of something that took a span of 2 years and gathered so much data that we're still in the process of assessing it, crunching the data, and putting it into a report that we will share later this year. It'll be publicly available to everybody. But I'd like to wrap up just very quickly, giving a few observations as to what, having been through this and being now a corporate counsel for 20 years, what would I predict will be the future of dispute resolution, why it's relevant to those of us who I think are working in the area of mediation. And that is that the world today, unlike when I started 20 years ago, is one where everybody knows what's going on everywhere else. Judges no longer work in national silos. Judges in courts know what judges in other countries are doing. They know how efficient other courts are. And so do lawyers who work there. We know that there's forum competition. Brexit may have a big impact on driving more international disputes to being resolved on continental Europe, for example. In Asia, there's big competition between Hong Kong and Singapore, because within Asia, certain cities are perceived, or certain fora are perceived to be more efficient. Dispute resolution is changing because society is changing with it, so dispute resolution is adapting. Over the next 5 years, I think that one of the key things that we will see that will begin to change is who are the business users of dispute resolution. One of the big, I'd say, differences I notice between my generation, I'm 56 years old, and the generation that's coming up of practitioners who are in their late 20s, early 30s, or even early 40s now, is that the current generation that's coming up knows all about these different forms of dispute resolution. They've been educated on it, they've been going to competitions, they are phenomenally open to trying new things, and they're connected with each other around the world. So when we think about the future of dispute resolution, I think the first thing to realize, it's not really us driving the future. It's the people who are coming along behind us, being people of my age or older or a little bit younger, but those who are coming up now in the pipeline. I think we have to think of who are those people and what are their mindsets and their values. So that's a big driver. For me. They're highly informed about dispute resolution. They're multicultural, multilingual, flexible in their approach. They've been engaging in competitions. They are practical. They are problem solving. The current generation, unlike my generation where we got trained on this is the law and this is what it says, they're trained to think about how do you fix the problem? Is this really a problem? What are the possible solutions? So I think the current generation is coming up much more practical in their orientation than the training that my generation tended to receive. I think they're also very impatient. They're socially networked. They want outcomes very quickly. So I think they're the ones who will be driving this process. Interestingly enough, too, they're not afraid of technology. They want more use of technology. And I think so companies over the next 5 years will be hiring people like that more than they're hiring people like me. And I think law firms are already hiring a lot of these people, and they're going to be becoming in more senior positions over the next 5 years. So for the next 5 years, I think the most important development for the future of commercial dispute resolution is it will be an emerging divide in procedures for high value, high complexity, and low value, low complexity disputes. I think the way that courts around the world are going to have to adapt to the demand on them is to find a way to get rid of a lot of the lower value, low complexity stuff. And they're going to introduce more technology, more rapid, fast-track procedures. We already see this with a lot of arbitration institutions and a lot of online dispute resolution that's beginning to emerge. So I think over the next 5 years, we'll see more of that. But more importantly, we'll see people like me getting comfortable and people coming up in the pipeline getting comfortable using these technologies. So they're only going to use them in the next few years for disputes under 5,000 euros, under 10,000 euros, under 20,000 euros. But here's what's going to happen. When people like me use something, maybe you use a system that says this is 80% accurate, right? Well, 80% accurate for lots of small value disputes of under, say, 5,000 euros, I can live with 80%. But once I say I can live with 80% for under 5,000, then you come to me with an improvement, it's now 82%. Well, let's try 10. Let's try 20. Once I say we go from 5 to 10, we're on a slope that doesn't end. And those automated procedures and the use of technology just begins, it's a gradual creep up to 5,000, 20, 50, a million, 10 million, as the systems become more robust, as the systems become capable of managing more complexity. This is how I think adjudicative dispute resolution is likely to go. It will use a lot more technology to do predictive justice, to be able to say, you're not going to win this case because we've been able to analyze 10,000 other similar cases on similar facts to yours, and this is the way things go. So I think it'll be a gradual approach that we'll see the beginnings of over the next 5 years. I don't think these tools are necessarily going to be adopted because they are better than people. I think these tools will be adopted because they're better than nothing, because they'll be able to pick up disputes that are not being used right now. But we're going to start to get comfortable with them. So then over the next, say, 10 years, I think is when we begin to see real game changers. I think now that you've got people like me, assuming I'm still working in 10 years, or the people who come along, will be used to using these sorts of tools. And we're going to be appointing lawyers who know how to use these tools, who have a broad toolkits of ways of getting results. And I think that we're going to see a big divide now between these adjudicative processes, and mediation will continue to be a much more facilitative process. There may be online forms of mediation, blind bidding, but I think that's where the human element is going to be very difficult to take out. Because while we become more safe or comfortable with the robots taking over the parts of the decision making, I think that we will be wanting to have the humans still interacting, the empathy, the ability to understand, the ability to bring out and try to understand the interests. Now, if I were to make finally just some bold predictions over the next 20, 25 years, I'd say we have to worry about the robots. There are a lot of projects in place right now for predictive justice and online dispute resolution, but I really do think that the adjudicative dispute resolution, where we've got high complexity, high value amounts over the next 20, 25 years, people are going to trust more in the machines to be able to get good results, maybe than they will trust the humans with all of our failures. But I think mediation, if I had to make a prediction, I still think mediation in 20 to 25 years is still going to be in the human domain. I think humans are going to need humans to help us work through human problems. So I think you guys, the media, I'm not a mediator, but you guys, I think you guys might be safe a little bit longer before the machines, we call them the robot overlords, take over. Just to quickly conclude, I just want to tie back to, this is Gavin today. He has lots of great prosthetic limbs, turns out. He just used that one for effect at the mediation. He's also got a great running one that he used. This is when he went on a race with a number of his colleagues from the office in Aberdeen. He coaches youth football. He's a big fan of Manchester, and he would not be a friend today without mediation. So, thank you.
Thank you very much, Michael, also for the story of Gavin, which when we finished fearing the robots, I think we'll all remember Gavin. Fabulous. Thank you very much. And in a second, I'll open for questions. We have, luckily, time. You said very early on that efficiency was at the top of the agenda of very many people who attended your conferences when it comes to dispute resolution. What does efficiency mean?
It's one where, I actually have a case right now where it's a high complexity, $130 million dispute, and we think efficiency means that it has to be over and done in 3 months. The other side has put in a submission. They want it to be done on 12 months. So I think efficiency is relative. I don't think there is a lot of agreement over what is. Usually it means faster than what you want.
Yeah. The reason I ask is I was expecting a lot of emphasis on cost and gains, whereas efficiency, of course, also translates into money at some stage. But how should we relate the two here? To what degree does funds, money, wins, gains mean something here?
Yeah. Well, so I get two answers to that. One, I'll answer you as a lawyer for a technology/manufacturing company, which is that efficiency, in my way of thinking, again, this is somebody who works with big machines and equipment, is really an expression of productivity. Productivity means that, if we can get the same bottle of water quicker at less cost, that's the efficiency. So how can we capture productivity? And then how do we, what was it?
No, I was just wondering, the term efficiency could probably be translated into many different things. Yeah. I'm sure there was a lot behind that particular priority by lots of people. So I was trying to get to the bottom of, or at least a little deeper into, what exactly is it that people ask for in dispute resolution? And is there any of the old kinds of dispute resolutions? I keep thinking that this is contrary to litigation and courts. Yeah. But is that correct? Is that a correct interpretation?
No, I don't think so. I think everything can be done. Look, when you work for a company, and this is true of any company, is that you always know that next year you have to be better than this year, right? So whatever process you're working in, you always have to be trying to make it more efficient. You need to be able to deliver the same product at a lower price more quickly.
Secondly, please raise your hands now if you want to add something or ask a question. The floor is open. But I'd like to ask you a second thing that I picked up on your slides here. You said parties expect greater cooperation from advisors in dispute resolution.
Yeah.
Parties expect greater cooperation from advisor in dispute resolution. What is this cooperation from advisors that the parties want? What exactly do they look for?
We had a lot of responses to this, and part of the question process that we had was when we actually gathered sort of free input from people, and this will come out in the final report, but I'll tell you what I think this broadly, from a lot of the sessions that we had, was they would like more, their advisors, the lawyers they work with, to have more tools, right? So don't come to me with just well, you signed a contract, let's say arbitration, and it says you have to go to arbitration and you'll just, under X rules, and it will be decided. Come to me with, how do I solve this conflict? How do I get to a settlement? How do I find ways of resourcing this? Come to me with solutions. Don't just come to me with well, here's the process, let's go off and do that.
And there, of course, mediation is part of the toolbox. It comes sort of with, as you say, in the future, this will be part and parcel of the young advisor's toolbox. To what degree, then, are the external lawyers still the obstacle? As you said here, external lawyers are seen, conceived, perceived as the primary obstacles to change.
Yeah.
Is that still so? And why is that?
This is perceptions
Yes,
of the respondents,
yes.
right? Is it the reality of the? I'm not sure that it really is. I think that lawyers want to help their clients find the best result that they can. And look, I made this joke last night. There's this old joke about there are two different types of people in the world. The first group is those who think you can divide the world into two types of people. But I think there are, sort of broadly, there are two types of lawyers. There are the lawyers who are focused on, this is the law, these are the rules, this is the process, this is how you win your case. And there are the lawyers who think, you're a client, you have commercial objectives, here's how we get you to a result, right? And they're not the same thing. They can be compatible. They don't have to be incompatible, but they're not I'm not a law firm. I'm not a lawyer for the law. I work for a company. I don't care if we win or lose. I want a result in the case. I do care if we win or lose, but I mean, it's like, to me, it's the result, right? If I can get the same result in less time through a settlement, well, then why would I fight the case?
Please.
Thank you. My name is Matthias Steiner. I'm a private practitioner here in Copenhagen, and I've been involved in some mediations, the US and England and in Denmark, and I think that, I'd like to ask, how do you cope with the different incentives of the stakeholders in the dispute? I thought about it when you told about the story with Gavin, that Gavin and you, coming from each of the parties, you want to be friends, you want to solve the case, and it appeared as if counsel was just wanting to have the dispute and wanting to have the fight. And of course, that's also part of their living, and I've myself come across that a number of times without making myself sound like a saint, but you have an opposing counsel where you think, okay, well, they really want to have this game, and they would really like to take it to court because that's their, 60 minutes of fame on that particular dispute. So you sort of have to align the interests of the counsel, saying we really want to solve this dispute as well. We don't want to take it all the way through because, so you have that difference between the real stakeholders and then the lawyers.
No, I agree, Matthias. I think that, so there's this terrible joke, which I do not agree with, that says that ADR is not accepted because ADR, being mediation, stands for alarming drop in revenues. But I don't agree. I think that's right. I think that the resistance you get from, it's not really resistance, it's the lawyers who are trying to do a good job for their client. And they're doing what they were trained to do, right? And a lawyer knows, I know how the judge works, right? I have that's my toolkit. I know how I even know this judge, I've been in her court before, I know how she reacts to things. I feel that you, my client, are safer in my hands if we go that process. The problem is it takes a lot for a lawyer to say, I'm going to separate from my comfort with taking you through that process and take you down another path where we don't know where that might, but it might actually result in a settlement. I think that's I
was also thinking sometimes you might want to somehow come across to your opponents directly, telling them, be aware that there's a game being played on the lawyer side as well. I mean, if you're comfortable with your own counsel, but you may not be equally comfortable with your opposing party's counsel, right? And that's a difficult nut.
That's my life, all the time.
Please, go ahead.
Yes. My name is Michael McIlwrath, and have been in-house for 25 years in a number of multinational companies, 10 years as general counsel. And I know that in Sweden we are still with the mediation a little bit on a, let's say, when it comes to the commercial part, on a uphill. And I'm just wondering, as I know it's very much more accepted in the US and England, that, I mean, because when I've tried to propose mediation for my CEOs and all that, it's always been looked upon as something unnecessary delaying to get the result. I mean, it's just a step to prolong the process. And I'm just picking your mind how we should approach it. I mean, there are two ways I see it. Either we just work on it by spreading the word and proving the efficiency of mediation, or you could also build it in long contracts as a permanent, so to say, that you have points in the contract development where you use mediation in order to limit the end dispute matters, so to say. I just want to have your view on.
But that's what we do. We because of that problem, we try to impose. And many of our customers, actually, I would tell you that I started as an in-house lawyer 20 years ago in Italy with global responsibility. It was very hard. And I came to mediation because I had a workload that was crazy. I had 143 cases when I was first able to count. And I said, I have to find a way to rationalize this. And so we embarked on an effort to try to resolve our cases any way we could, negotiation, but we proposed mediation. I'd say out of 20 offers to mediate, one might get accepted. So it was hard for, and internally I didn't have as many problems because I'm the head of litigation, so I'm a little bit of a gatekeeper, you know, so if I say we do this, we do. So I have a bit more control there. But I've found that putting a requirement in contracts is huge. Because even I'm pro-mediation, but there's certain cases, you know this too, you get this, you go, they're a bunch of idiots. Why would we want an idiot? I'm not going to do this case. And then you get in the mediation, you go, oh, God, we're a bunch of idiots. Why did we let this get so far, you know? I think that's one way to do it. The other problem, too, I think we face is, and we were talking about this with Martin last night, is that the word mediation, and it cognates in different languages, is terrible. Because it doesn't really capture what this process is. What's really, you know, if there were a word, it would probably be some awful German word that's like, 120 letters long and explains every single detail of the process. It's all problem solving.
Michael, we are rapidly moving towards the Danish case, but give us a few words before you leave the stage for now on a couple of selling points on mediation. When you want to talk somebody into mediation, so one of the parties in a conflict, and you want to say, listen, I know that these are the three main things that you could look for in mediation. What are the benefits to cut to the bone?
Well, I'd say there's no downside. I mean, first of all, there could be a downside if you have a mediation with a mediator who's not really qualified. And this is one of the reasons that my company and I got involved with the International Mediation Institute, is that you really do need to go. The worst thing that can happen in a mediation with a good mediator is nothing happens. You've not lost any time. You've spent some minor additional amounts of money on your case, presenting it to in the presence of a third party. And, you know, so I think that really, to me, the best selling point is you have nothing to lose, really, and only to gain by engaging in this process. That would be my pitch, but anyway.
Thanks very much. We'll leave it there for now, and then you'll be back up here later. Thanks very much, Michael McIlwrath. Thank you.